Okay, the next case we'll take up will be Earth Trades versus T&G Corporation.
Good morning, Your Honors. May it please the Court. My name is John Shahady. I represent the appellants Earth Trades, Inc. and for SEALORD Surety. I'd like to reserve 5 minutes for rebuttal. Your Honors, the main issue on appeal is, under the current state of Florida law, does an unlicensed contractor and its surety, is it required that a default final judgment basically be entered against them on the issue of liability based solely on their unlicensure? That's the main issue. The second issue is, can a general contractor in this case collect damages that are not contemplated by the contract? But obviously the main issue that I'm addressing here is the trial court overruled established law in this district and found that based solely on the unlicensure, a contractor and its surety were precluded from asserting any defenses at trial, leaving them with the equivalent of a default judgment against them, except for damages. Very briefly, the summary of the facts in this case.
Well, was the plaintiff required to prove that the subcontractor that your client had not done the job in accordance with the contract and performed the job in a defective manner? What
was left was the defense of set-off was not allowed. The defense of reasonable cost to complete was not allowed. It was simply that the general contractor was required to show the work they were doing was within the scope of the contract, and that's all. But
if the trial judge found that your client had properly performed the contract, notwithstanding the lack of a license, would the result have been a zero verdict, if you would, for the appellee?
I don't think we can go there, Your Honor, because of all the issues that happened before that. The set-off issue wasn't even allowed. The issue of liability was already determined. So it really wasn't an issue of whether there was a breach of contract or not. It was already determined via summary judgment. It was simply an issue of were the damages within the scope of the contract. So I can't answer that, and I don't think the trial judge was in a position to answer that. What happened here was this is the light most favorable to the non-movement on summary judgment, and the subcontractor alleged in an affidavit that the general contractor was well aware he was unlicensed. There was no question. Actually, the general contractor provided a recommendation for the subcontractor to become licensed. There's no question as far as that's concerned. What happened is there was a dispute over the work, and as a result of the dispute, a legitimate claim by the subcontractor for $180,000 was entered from the lawsuit. The general contractor counterclaimed for $500,000. It wasn't until after the lawsuit was filed that the licensing issue became part of this case, and there was an amendment. The trial court overruled the law of this district, found that the Governor case, and I'll discuss that in more detail, didn't apply, and that the subcontractor and its surety could not assert any defenses. As a result of that, at trial, the general contractor took a claim that was based on a $265,000 contract, that there was a withdrawal request certifying it was 97% complete, and allowed that claim to become a claim for $500,000 with a judgment against the surety for $600,000 and the subcontractor.
So you've got the rule, the peri delicto, the knowledge of the lack of a license and how that impacted the handling of cases, and then the legislature goes ahead and changes the statute.
That's correct.
Why isn't that an indication of legislative intent to address the law in this district and other districts and effectively legislatively change that law and provide that if you're not licensed, you're out of luck?
Well, the statute changed. There were certain changes by the statute. The statute added that it was unenforceable, the contracts are unenforceable in law already by the unlicensed contractor, and that was done to clarify existing law. It wasn't done, and there's the Promontory case, the 5th District case, it stated that it was done to clarify existing law, not to change it, and it was retroactive in nature, but it's very simple. What it's saying, and there's no disagreement with that, is if there's an unlicensed contractor, enters into a contract, that unlicensed contractor cannot enforce its contract. And that's what the statute says. It also says a surety cannot say, wait a minute, this contract's unlicensed, therefore I'm not going to pay a bond. What it does not say is an issue that we have here where there was knowledge on the general contractor's part that the sub was unlicensed. The general contractor knew it. It even entered a letter of recommendation, sent one to the state when the subcontractor was licensed.
There was a disputed issue of fact as to it.
Disputed issue of fact, but for the purposes of summary judgment, it really doesn't matter because the judge didn't even go there. The judge said, listen, I'm not even going to go there because I feel under the statute it's clear. And the Caverner case I'm not going to even discuss. There's no defense. Doesn't matter what the affidavit says, there's no defense. But going back, the statute just clarifies that under those circumstances where there is an unlicensed contractor, he cannot bring a claim, and a surety can't say, I'm not paying that claim based solely on the unlicensure. It leaves an open issue of imperi delicto and knowledge. That was not, the Caverner case was not overruled. This statute, as amended in 2003, didn't change that. And it certainly hasn't changed that. And this court, in the Boatwright case, and I'll explain further, even explains that. So, yes, the statute
I'm
changed.
still having a problem with understanding your first statement that the trial court, in effect, granted summary judgment on liability. I mean, didn't the plaintiff still have to put on evidence that your client failed to perform the contract properly?
No, because what the court did was basically enter the equivalent of default, finding liability. The only thing left was damages, and I made an analogy that all that was left, just like a default judgment would have been entered on liability. The only thing left was damages, and the surety and the contractor were even more limited. They couldn't argue. All they could argue was that under the scope of the contract, the damages were not contemplated by the parties.
What additional evidence would have presented that was not presented to the trial court?
Set off that there's $180,000 that was owed to the to the subcontractor.
On this job?
Yes, that there was a pay request made to the general contractor to the owner, affirming that 97% of this job was complete. That of a $260,000 contract, $256,000 was completed, and also evidence that the owner paid the general contractor for this work. And also the evidence that the work done exceeded the scope of the contract, and that as a result of the engineer...
That was tried.
That was tried. But these other issues, that the cost to complete was not reasonable. The cost to complete based on that trial request was not reasonable.
Wasn't that tried too?
No, it wasn't. That was agreed to. That couldn't be tried. It was agreed to beforehand. That the reasonableness of the cost to complete was not an issue. So there have been a number of issues that would have been addressed, and the most important one was that if the evidence would have shown the general contractor had knowledge, then its claim would have been completely dismissed. That's the law under Caverner of saying that. So there would have been numerous issues that would have been addressed at the trial. And the trial, the surety especially, had his two hands behind his back. It really couldn't do any sort of defense.
Leaving out Caverner and the other DCA cases that reached similar results, and leaving out the prior statute, if you just took the statute in its current form, or the statute as it existed at the time that this case was litigated, what do those words mean to you? This section shall not affect the rights of parties other than the unlicensed contractor to enforce the contract lien or bond remedies, and the provision that the contract with the unlicensed contractor shall be unenforceable in law and equity by the unlicensed contractor.
And that's what happened here.
I mean, is that language unambiguous?
That language is very clear, but it's by the unlicensed contractor. Meaning, and that's what happened here. The unlicensed contractor had a legitimate $180,000 claim for extras and work that wasn't paid. That was paid by the owner of the GC, but wasn't paid to the sub. That's out. That's out pursuant to this pursuant to the statute. It's by the unlicensed contractor. The statute also says a subcontractor cannot, a surety cannot say, I'm not paying a bond claim based solely on licensure. What we have here, though, judges, is an issue of knowledge and imperi delicto that's not addressed by the legislature. It's not addressed by this statute. and that is the common law of, one, wrongdoing by all parties, and two, especially in the surety sense, understand here the surety has separate defenses. Notice the surety's claim is on the bond, not on the contract. So the surety's defense wouldn't be in peri delicto because they're not party to the contract.
Well, you
They
said
have
the
their own bond
legislature
claim.
didn't address the impaired delicto defense, but what about the provision, this section shall not affect the rights of parties other than the unlicensed contractor to enforce a contract lien or bond remedy?
I agree, and that by itself, just because the unlicensed contractor can't bring a claim, the owner or the other side can bring a claim. Just because it's unenforceable doesn't stop them, except under the common law, and this just clarifies the law. That's always been the law, Your Honor. It's always been the law that the unlicensed contractor can't bring the claim. The owner or the other party can, unless they acknowledge, and this clarifies the law, saying yes, they can. It doesn't say under any circumstances, and it certainly doesn't say.
Well, why wouldn't the section say, this section shall not affect the rights of parties other than unlicensed contractors, provided the other parties did not have knowledge of the unlicensed contractor's status?
Well, I don't think that's necessary, because what it's doing is clarifying the law before, saying that under that scenario, the owner can. I don't think the statute
What
would
needed
allow.
clarification?
Excuse me?
What was it that you think needed clarification?
It was clarifying that the owner,
Clarifying what?
that the unlicensed contractor cannot bring a claim. The other party to the contract can bring a claim, just based on that situation.
And what is it about the prior statute that didn't say that?
They added by the unlicensed contractor. I don't know if they made it clear enough. They were making it very clear. It said by the unlicensed contractor. The other statute didn't specifically state that. But again,
But the other statute specifically stated that the unlicensed, that you couldn't bring a claim if you were unlicensed. That aspect of it wasn't clarified in any respect, correct?
it was clarified to say by the unlicensed contractor. Yes, but even this was addressed by this court subsequent to the 2003 amendment. In the Boatwright case, which Judge Evender,
Yeah, but the Boatwright case, the general contractor was out of the picture in 2001, which was 2 years before the amendment. The Boatwright case was a lawsuit between the unlicensed contractor and the qualifying agent, who really hadn't complied with the statute to be a qualifying agent. The general contractor was out 2 years before the amendment to the statute.
Right, I understand that, but this court made a specific finding in the Boatwright case, saying that the unlicensed contractor could not bring a claim. But then
Back in 2001, that would have been undisputed under the 5th CCA's law.
Well, what happened was that this 2003 amendment was retroactive. Legislative intent was that this was retroactive. So under the Boatwright case, the amendment would have been in place at the time of the decision, which was 2007.
The promontory case dealt with whether a certificate of authority was necessary as well as the license.
That's correct.
So the fact that it was retroactive in that regard may or may not mean that this was retroactive.
Well, it said, I apologize, it said 1, 2, 3, and 4, the legislative intent was each part of the new statute was retroactive. That was legislative intent, and that's in the promontory case. So this was retroactive at the time of the Boatwright case, and in your opinion,
Right,
Your
but the
Honor,
Boatwright case, there's about a 4-year lag actually about more than that, by the time the general contractor was out, and the parties ended up having their case resolved in court. So in 2001, the general contractor, would not have had a claim under the Kvarcher case. Now, whether that would have changed, 2-3 years later if there had been a lawsuit, maybe, maybe not. But the general contractor was out of the picture in 2001 in that case.
I understand, Your Honor, but your pronouncement, and based on the retroactive nature of this statute, I don't think you would have made that pronouncement. You said it's also questionable whether the owner could bring a claim against the unlicensed contractor. That was in 2007, and that was based on looking at the law retroactively. So,
Are you suggesting that Boatwright was imprecise in its use of language?
no, I think it was right. I think it was basically saying at this time there's still a question, and they're relying on the Castro case which is a third DCA case in 1994, which stands for the proposition the owner knows of the unlicensure, the owner's barred. And really, the Converter case is right on point. That's a 2003 case. I don't think it's been, there's nothing in any cases subsequent. I think Boatwright is saying it's still good law, because Boatwright cites the Converter and cites the Boatwright cites the Converter. But Converter is right on point, saying that a surety, if there's a unlicensed subcontractor, the surety is not liable under a payment bond if the general contractor knows of the unlicensure. That's a 2003 case out of this district, and it has certainly, there's nothing to indicate that's changed. To allow such a change would deprive the surety of its separate defense. As I said before, separate defense of knowledge. And the Converter case goes in detail about that, not just in peri delicto, but a separate common law defense of knowledge. Under the Converter case, if the obligee, who's the general contractor, who had knowledge, that would, in the 5th District, in this district, actually grant summary judgment in the sub's favor, but it certainly creates a question of fact. The policy reasons behind not allowing the trial court's interpretation to survive on appeal are, this statute is a consumer protection statute. It's doubtful that it was meant for a situation where there's a legitimate clash between a general contractor and its sub regarding payments, especially when payments come from the owner. There's a legitimate dispute here. It's not to be meant to use that legitimate dispute as a vehicle for a default judgment to be entered against the unlicensed contractor and its surety. And what this would do would encourage abuse of sureties by a general contractor in the instance, actually trying to find unlicensed contractors. Because finding an unlicensed contractor who does good work and then not paying them when they get paid by the owner and saying, wait a minute, you're unlicensed. Therefore, you have no claim.
Surety have the right to decline to issue a bond to an unlicensed contractor?
Absolutely. They have the right. But
isn't that the remedy for sureties?
Well, that is one remedy, but the problem, it's still going to have a problem with unlicensed contractors also. That the public policy argument, excuse me?
I'm sorry. You're down 3 minutes or so.
Okay. That's what the issue is here. The problem is for contractors and for sureties, this will be abused by the fact that they can pick unlicensed contractors, not pay them, and get basically a default judgment against them. As far as the next issue, I'll defer to the brief, but it created an issue where the only thing that could be addressed at trial was the scope of the work, and based on the draw request alone, the fact that the work was 97% complete would show that the scope was substantially completed, and to allow damages that far outside of scope is beyond what the evidence required. Thank you.
May it please the Court. My name is Kimberly Ashby. I represent the Applee T&G Corporation, doing business as T&G Constructors, which was the general contractor on the job that we're speaking about. That's the Florida National College job. The trial court should be affirmed, and the final judgment should be affirmed, because the summary judgment that was granted was directed to the affirmative claim of Earth Trades, Inc., and as it related to the fact that Earth Trades, Inc. admitted there was no issue in the record that it was not licensed, not as anything. And 489-128 prevents Earth Trades from going forward.
There is an issue as to whether your client knew.
To the extent they raised impera delicto as an affirmative defense, there is record evidence that Mr. Henderson said at various things in his affidavit.
There's a question of fact.
Okay, yeah. Even though in his affidavit he says he hedges quite a bit, because he doesn't give us any dates about when T&G supposedly knew that he was unlicensed. If you go through the record. Okay. But I don't want the court to see this as, okay, the general contractor got away with one here. Because this is not one of those cases where, and there have been, where there's a complete windfall And that is a notion that I really need to dispel to the court. And this whole specter of, well, T&G got paid for this work. Let me just tell you,
I understand what you're wanting to go to the argument that he hasn't, raised yet, but isn't there a policy consideration that wouldn't a ruling that effectively negates that defense allow general contractors to find unlicensed contractors, and they would be really at the complete mercy of the general contractor?
Here's why the concern of the boulder in the pond. What kind of activity are we going to encourage if we find that the surety in this case, certainly Earth Trades doesn't have any claims on its contract, it's void. When the change was made in 2003 to include that prohibition to the sureties as well, and you say, well, aren't we unnecessarily tying the hands of the surety? What it's important to note is, what is the role of the surety in this situation? Is the surety some blind person coming off the street who has no knowledge and no ability to know what its own principal has and doesn't have, and what this contract is and isn't? And this record, and what we did try, and Mr. Fisher testified, he was the surety's representative, that he reviewed this contract going into this job. And we asked...
Leaving out the surety, I think it was the second DCA had language that to negate the imperative elective defense would mean that a general contractor would be encouraged to go out and hire an unlicensed sub. So leaving out the surety, I think Judge Cohen's question was, with a ruling to affirm, would that promote general contract or encourage general contractors to do something like that?
You need only look to the facts of Boatwright and Kverner and the cases that have decided cases where you've got general contractors and subcontractors involved, and look at the parade of horribles that you would have as a general contractor for knowingly pulling a subcontractor onto a job that it needs a license and doesn't have one. Number one, Boatwright, you're going to get red tagged. Okay? Number two, if you need to pull a permit, which is what happened in this case, as soon as Earth Trades got to the point where they needed to pull that underground permit, they couldn't.
Well,
and they abandoned the job.
A losing proposition with the owner.
Of course. And guess who the owner's going to visit that on? The general contractor. This isn't like Castro, okay? Castro's facts are really important to distinguish from this kind of situation in a commercial construction setting with a very large project, a 3-story parking garage engineered to go 5 stories in the air. You're going to pull an unlicensed underground contractor to do the site work and compaction for that kind of a structure. This is in Castro. This was the owner going down and telling the building department, I'm the owner, I'm going to pull an owner's permit, when all the while he was going to have this unlicensed general contractor.
But isn't that precisely what happened here, is that the general contractor secured an unlicensed sub?
Unknowingly, but let's assume for a second that they knew and pulled them onto the job. What we have is, we have a bonded sub. Okay, and the distinction on that front, and that's why this is important for you to understand, we requested judicial notice be taken of the website of First SEALORD. This is what they are representing to you when you get a bond from them, is they are vetting the subcontractor for you. And in the materials that were never objected to and came into evidence, First SEALORD represents that it is providing the contractor evaluation and making sure that they have the appropriate experience, training, licenses, and/or certifications. It might be strange to see, this is my case, I tried this case. We didn't raise a license issue until a year or so into it because we didn't know about it. And when we found out about it, of course, we raised it. Because why wouldn't we have looked to see whether the license? Because the surety is representing to that's part of what you're paying for when you buy and pay a premium. When you buy a bond, and it's a performance bond and it's a payment bond, and they're representing to you, we have done the due diligence for you. We have vetted this subcontractor, and we are representing to you that this subcontractor is fully experienced, licensed, certified to do this work. So,
as a result of the trial judge's ruling, what evidence was Earth Trades prevented from putting into evidence?
Impaired delicto is it. And I also want to point out that when we got to summary judgment, on my motion for summary judgment, to strike the impaired delicto because it no longer applied, and I think the court's questions to opposing counsel indicate that you're well familiar with what the chronology on that was. At summary judgment, the discussion was had, and in pretrial, what are we going to try then? And we decided what we were going to try was the issues relating to what T&G had to spend to complete the contract, and there were no other issues to try. So we got to trial, and trial counsel, Mr. Tom Shahady, indicated they wanted to go back and challenge some of the liquidated sums that were paid. We paid Earth Trades suppliers. The fill that they'd put in, they didn't pay for any of those. We had to pay for those out of pocket. All of these things we had stipulated, that's not going to be an issue. So at the beginning of trial, and you can look at the transcript and see this discussion, there was, wait, all right, what are we trying now? Okay? And then when we got to the point where trial counsel attempted to bring up whether there should be additional set-offs for the other job, I objected as irrelevant. Discussion was had, I'm speaking of page 157 of the transcript, discussion was had, wait a minute, when we talked about what the issues were for trial, this was not included. And, Ms. Ashby, that being me, the trial counsel has now been hamstrung of what witnesses we would have brought to address those issues. And the response was, well, we want to try them now. The judge disallowed that evidence because of the prejudice to our case in what was decided would be the remaining issues, not because there was a blanket thrown over and a default entered. The court could have entered a default. It didn't. It granted the motion for summary judgment, which was directed to the defenses that were the impaired delicto defenses because Castro had been overruled by the amendment to the statute. That's it. We tried this case for a full-on day until like 6:30, 7 o'clock at night, and they brought all the defenses they wanted to. We performed the contract. The expenses that you incurred were unreasonable or not necessary to complete the original scope. They brought an expert. We talked about what that original scope was.
Quantum Merowit?
There was no quantum Merowit claim brought by anybody. So quantum Merowit was never an issue that anybody ever raised in this case. I sued on the contract against Earth Trades and on the bond claim, the payment and performance bonds against First SEALORD. Period. That's what was before the court. There were no equitable claims that anyone brought.
Set off?
The set-off claim, when they raised it during trial, Judge Lawton didn't disallow that because of the summary judgment ruling and that there was an impaired delicto blanketed that. He disallowed it because when we discussed what issues we were going to be trying for at the non-jury trial, this wasn't one of them. And so that was...
Set off from another project?
Sorry, yes. Yes.
ABC project?
Right. Also without a license. And they never contested that summary judgment was appropriately entered against Earth Trades because it was inappropriately licensed. So I just want you to appreciate that this isn't a situation where T&G is going to sneak out with the money. The original amount of money that was spent and paid by the owner was for all that bad fill. Spence Weaver is describing bags of garbage that were in the fill. When they cored down to see what was in there, they had to strip all of that out, down to the hard pan, and put in the only fill they could find to suit the Proctor, which was this very high-grade DOT. We're now way behind on the schedule. This is the beginning of the critical path. Everything that we tried was on the table because these were the remaining issues. The only issue the court dealt with was impaired delicto. If there are any other questions, I'd be happy to address them. Thank you very much.
Sir, you have a little over 2 minutes.
Just briefly, Your Honors, the issues at trial were not just impaired delicto, as I said before. What the court did was grant effectively a default judgment, which wouldn't allow any of the other issues to be addressed. cost of complete, reasonable cost to complete, and other issues. It wasn't a trial decision. It was a decision by the judgment. But Your Honors are correct that, again, this sort of allowing the trial court to overrule established law in Coverner would create the problem that was discussed, you discussed with the general contractors allowing or encouraged to hire a licensed contractor. And one thing I didn't address would severely restrict a surety's access to the courts. That's a vested right, and basically under a decision which this court would affirm, or in an opinion, a surety's rights under this situation would be completely null and void. And they have vested rights, and that's a constitutional issue. And that's something that wouldn't be allowed because it would basically...
Was that raised below constitutional aspect of access to courts?
It was not raised below. It was raised in the brief.
If you don't raise it below, you can't raise it here.
Well, and I understand the only exception would be a fundamental error issue, and a constitutional issue is a fundamental error issue. So I would address that on... It was the same intertwined issue that basically there's default judgment against you, but it's raised in the brief, and I would suggest that that is an issue that can be visited on appeal because it is fundamental. So based on the Coverner case and based on all the issues, I'm not saying that the surety or sub are going to win. They need to have their ability to at least defend themselves in court against a situation like this where a general contractor is going to say, okay, you're unlicensed. We're going to ask for 3 times the amount of damages that the contract allowed, and we're going to get it because we get a rollover here. Because really the surety and the subcontractor can't maintain any defenses. And that's not right. And on that basis alone, this court should reverse the summary judgment and allow the case to go to trial where the issue of knowledge should be a main issue. Thank you.
Thank you.